Because when you sit down to read a piece of legislation, in some of them, they will refer you to 15 different pieces of legislation. And you have to go there, you have to pull that section, you have to insert that section just so you understand the paragraph that you are reading. That's why legislation is so hard to read. And yet the majority of the legislation in this province actually does not infringe on anyone's rights. Even in the Municipal Act, it states under Section 10 and Section 11, subsection 2, Part 4 of that section, bylaws, it states, a municipality may pass bylaws to acquire assets, to exercise it, as a corporation, its authority under the Municipal Act or any other act. Is the Planning Act not another act? Is the Building Code not another act? The conservation authorities were created by a deal between the province and the municipalities to cut the costs. They are not to have any permitting or licensing authority over private property because it is not under their jurisdiction. Not only that, you can whack them upside of the head with your common law rights because you own the water, because it's the heaven and hell theory. You own up to the sky and to the center of the earth, and you own the water. And as someone said earlier today, it is just a water grab by the conservation authorities for you to be forced into giving up your rights. And that was at the recommendation of a 1999 report, and it was presented to the University of Guelph. This report was done in one of the driest years. They did a study on, I think it was 47 different farms, and they were in the driest part of the province, to prove that the conservation authorities felt that you could not look after your water. It's in my big report. This is why the Mississippi Bills and a lot of the conservation authorities are really starting to back down from the Ontario Landowners Association, because you wonderful people, thank you for coming, are learning your rights and you're starting to stand up for them. So thank you. So, am I done?
A couple more questions.
Kimmy, what do you want, Kimmy?
You okay to continue?
Oh, yeah.
Okay. Two more questions.
I just want to know, when somebody says we have inalienable rights
Yes.
under such and such, what does that mean?
Inalienable rights are the rights you get from the very first breath you take. And I will repeat them again, according to Blackstone and Sir Edward Cook. And if anybody's wondering what Blackstone is, Blackstone Commentaries, I have the 4 volumes from, I think it was in the 1800s. Each book has got about anywhere from 1,500 to 2,000 pages in it. Read them puppies. Anyways, according to Blackstone, your inalienable rights are life, limb, liberty, meaning your freedom to move, to associate, to be friends with, religion, and your freedom of private property, for you to do with that property as you see fit. And private property also includes freedom of contract. That is what your inalienable rights are. They are, some call them your gifts from God. And this is the problem. Trudeau's charter, I've found this lately, Trudeau's charter is actually, as far as I'm concerned, a communist document, and I have the proof. Trudeau's charter is based on what's referred to as the Hegelian Dialectic. People, what I have found over the last few years is if we don't start picking up on the terminology that they're using, they're going to continue to hoodwink us. So I'm going to explain to you, I got 3 minutes. Can I do this?
I will give you 3 minutes.
Okay. The Hegelian dialectic is just a fancy $50 word for discussion. The Hegelian philosophy of right is the philosophy that Karl Marx used. The Hegelian philosophy of right is what Stalin used, Mao used. Everybody says, oh, this is such a wonderful doctrine, you know, oh, you have to read it. Well, I've read it. I did. I actually read philosophy to know and understand what this is all about. It removes God or your inalienable rights, and it replaces it with the state. The state becomes your new God. That's what the Hegelian dialectic or the Hegelian philosophy is. To me, this is nothing new. Julius Caesar did it. He felt he was God. William the Conqueror did it. He felt he was God. Hitler did it. He felt he was God. Mind you, he studied Hegel. So did Otto von Bismarck. But for us in Canada, the reason we're having this Hegelian influence is because it started back in 1881 with a guy named Viscount Haldane. And he was some mucky muck in the Parliament of England, and he was on the Privy Council, and he was a Hegelian, and he didn't like our Constitution, the true intent interpretation of our British North America Act. So he changed it. In the Constitution, there is section 9213 and 9216. 9213 says the provincial governments may create legislation for property and civil rights. 9216 says they may create legislation for all things merely local and private in nature in the province. The screw up on that one was, and what Viscount Haldane pushed through was, that it meant that the province could write legislation for everybody. No. The preamble of the British North America Act restricts that. Section 91 and 92 have to be read in conjunction with each other. And that property is only the property that belongs to the province. It is not your property. Your property belongs to you. And my next book will be on the true intent and interpretation of the British North America Act. This is not me saying this, people. This is Frederick Vaughan, who was a professor of law emeritus at the University of Guelph. This is Richard Gwynn. He used to be, or still is, a columnist with the Toronto Star. He wrote a book last year called Nation Maker, the John A. Macdonald life. And it's right in there. Trudeau was a Hegel. What are you pointing at? Is he good looking? Who's the man?
I have a question.
Oh yeah, you're not bad.
Going back to the 60-year rule, if you had a road allowance to your property and nothing's been done with it,
Title searches.
okay, but after the 60 years, would they lose that right?
No, have you done a complete title search?
Not yet. I have.
Okay, you have to have a complete title search done because there may have been an agreement by a previous owner dedicating that land to the municipality. Okay. If that has been done, then you're pooched. If not, I would refer you to Grist versus Meaford 2011, 2012, and 2013. If you have not formally dedicated, there is no designation. So that's the other avenue you have to look at. Because dedication is a very formal thing, particularly when it involves the municipalities, and that includes you granting by grant in deed, meaning it's registered against the title, and then the municipality actually has to pass a bylaw to accept that dedication by that person, and they also have to accept the maintenance of. Now, they don't have to do the maintenance because if it's just an old road that, but it depends on who it belongs to. And that's the other thing. If you have not done complete title searches back to your Crown grant, you have no idea what you do or do not own. Am I done? Did I answer you?
Yes, and just one quick one. Will they have rights to put meters on our wells?
No. And if they try to, you fight tooth and nail. I know I have this lovely stone thing surrounding the top of my well. What do you got? It's going to take a major construction company to move that puppy. This is where they're trying to force you to give up your water rights. Same with septic stuff. They don't have any right to inspect your septic. That's your responsibility. And if people are going to be shirking their responsibility, all you're doing is making it so that they can say, told you so, we're right, you guys are a bunch of slackers, you don't know what you're doing, so we got to pass this legislation to take away your rights. And if anybody in this room has the nerve to phone bylaw on your neighbors, you do not believe in private property rights, because every time you do that, you're giving up your own rights. Every time you rat out somebody because they're doing something different with their property, you're ratting yourself out. And the big thing we all have to try and get across to our councillors, particularly our municipal councillors, is not necessarily that they work for us, they do, but the key component is there's already been a mayor that did not get elected charged under his own bylaw. He had to go to court and fight it, and he realized just how frickin' stupid this bylaw was. Now we have another councillor, her and her husband have been charged for a greenhouse because of anonymous complaints and because people don't even know anything about the law anymore. If you don't like what your neighbor's doing, you don't phone bylaw, you phone your lawyer and you launch a tort. And they're not blueberry. And they aren't tasty. They're a tort, not a tart. And when you launch them, you're not starting a food fight either. But this is where we have to get back to the basics. And we have to explain to our councillors that every time they think they're doing something good for us by passing a bylaw that restricts us, they're screwing themselves and their own children. Listening to staff is not the way to go, and yet when you read the Municipal Councillor's Guide, the whole thing is talk to staff, talk to staff, talk to staff. There's only one section in the whole document, and it's a book this thick, that states that staff cannot give you legal advice, and that's under bylaws. So whenever a municipal council gets the official plan, they think that planner has read the Planning Act and is fully cognizant of what's in it. I bet you there's not one planner in this province that's ever read the Planning Act, and I know that the majority of the planners don't know that you have to read that in conjunction with the Municipal Act. The two acts go together, because in 1946, it referred to the fact that you had to go back to Section 406 of the 1946 Act for restricted areas. And under restricted areas, there was the determination that the municipality had to ensure the cost of the construction wasn't too high. Well, can they determine the cost of your construction on your property? No, they can only determine it on their own property. So now you know why the Planning Act is only applicable to municipal properties and the properties of the boards. Am I done?
Yes.
I'm done. Thank you, everybody, so much.